Bankruptcy is a legal status of a person or other entity that cannot repay the debts it owes to creditors. In most jurisdictions, bankruptcy is imposed by a court order, often initiated by the debtor. Bankruptcy is not the only legal status that an insolvent person or other entity may have, and the term bankruptcy is therefore not a synonym for insolvency. In some countries, including the United Kingdom, bankruptcy is limited to individuals, and other forms of insolvency proceedings are applied to companies. In the United States, bankruptcy is applied more broadly to formal insolvency proceedings. In France, the cognate French word banqueroute is used solely for cases of fraudulent bankruptcy, whereas the term faillite is used for bankruptcy in accordance with the law. Etymology: the word bankruptcy is derived from Italian bancarotta, meaning broken bank, which may stem from a custom of breaking a money changer's bench counter to signify his insolvency, or which may be only a figure of speech. History: in ancient Greece, bankruptcy did not exist. If a man owed and he could not pay, he and his wife, children or servants were forced into debt slavery, until the creditor recouped losses through the physical labor. Many city-states in ancient Greece limited debt slavery to a period of 5 years. Debt slaves had protection of life and limb, which regular slaves did not enjoy. However, servants of the debtor could be retained beyond the deadline by the creditor and were often forced to serve the new lord for a lifetime, usually under significantly harsher conditions. An exception to this rule was Athens, which by the laws of Solon forbade enslavement for debt. As a consequence, most Athenian slaves were foreigners. The Statute of Bankrupts of 1542 was the first statute under English law dealing with bankruptcy or insolvency. Bankruptcy is also documented in East Asia. According to Al-Makrizi, the Yatta of Genghis Khan contained a provision that mandated the death penalty for anyone who became bankrupt 3 times. A failure of a nation to meet bond repayments has been seen on many occasions. Philip II of Spain had to declare 4 state bankruptcies in 1557, 1560, 1575, and 1596. According to Kenneth S. Rogoff, although the development of international capital markets was quite limited prior to 1800, we nevertheless catalogue the various defaults of France, Portugal, Prussia, Spain, and the early Italian city-states. At the edge of Europe, Egypt, Russia, and Turkey have histories of chronic default as well. Modern law and debt restructuring. The principal focus of modern insolvency legislation and business debt restructuring practices no longer rests on the elimination of insolvent entities, but on the remodeling of the financial and organizational structure of debtors experiencing financial distress so as to permit the rehabilitation and continuation of the business. For private households, it is argued to be insufficient to merely dismiss debts after a certain period. It is important to assess the underlying problems and to minimize the risk of financial distress to reoccur. It has been stressed that debt advice, a supervised rehabilitation period, financial education and social help to find sources of income and to improve the management of household expenditures need to be equally provided. During this period of rehabilitation, in most EU member states, debt discharge is conditioned by a partial payment obligation and by a number of requirements concerning the debtor's behavior. In the United States, discharge is conditioned to a lesser extent. The spectrum is broad in the EU, with the UK coming closest to the US system. The other member states do not provide the option of a debt discharge. Spain, for example, passed a bankruptcy law in 2003 which provides for debt settlement plans that can result in a reduction of the debt or an extension of the payment period of maximally 5 years, but it does not foresee debt discharge. It is almost impossible to discharge student loan debt by filing bankruptcy. Unlike most other debtors, the individual with student debt must give a series of reasons and tests to prove that the debtor could not pay the debt. If the person were to file bankruptcy, he or she is normally encouraged to do so under Chapter 13. In order to avoid bankruptcy, one could negotiate with the lender to lower monthly payments, or one could seek student debt consolidation. Student loan bankruptcy is considered a last resort. However, some borrowers find themselves being forced to file bankruptcy, as the lender refused to lower payments, or to lower, freeze interest rates. Fraud. Bankruptcy fraud is a white-collar crime. While difficult to generalize across jurisdictions, common criminal acts under bankruptcy statutes typically involve concealment of assets, concealment or destruction of documents, conflicts of interest, fraudulent claims, false statements or declarations, and fee-fixing or redistribution arrangements. Falsifications on bank. Multiple filings are not in and of themselves criminal, but they may violate provisions of bankruptcy law. In the U.S., bankruptcy fraud statutes are particularly focused on the mental state of particular actions. Bankruptcy fraud is a federal crime in the United States. Bankruptcy fraud should be distinguished from strategic bankruptcy, which is not a criminal act but may work against the filer. All assets must be disclosed in bankruptcy schedules whether or not the debtor believes the asset has a net value. This is because once a bankruptcy petition is filed, it is for the creditors, not the debtor, to decide whether a particular asset has value. The future ramifications of omitting assets from schedules can be quite serious for the offending debtor. In the United States, a closed bankruptcy may be reopened by motion of a creditor of the U.S. trustee if a debtor attempts to later assert ownership of such an unscheduled asset after being discharged of all debt in the bankruptcy. The trustee may then seize the asset and liquidate it for the benefit of the creditors. Whether or not a concealment of such an asset should also be considered for prosecution as fraud and/or perjury would then be at the discretion of the judge and/or U.S. trustee.